Good afternoon, my lords. I was going to move on to Respondents' Notice Point 3, and there will be powerful echoes of earlier discussions here, because this is a point about legal causation, but it's about legal causation and the intersection with patents, which we say follows from the dicta of Lord Nichols and Lord Hoffman in particular in the Kuwait Airways case. In effect, the judge decided legal causation as if this was just a sort of a breach of contract or something like that, or another tort. She didn't need to look at the patent-specific considerations that applied, and if she had done, they would have provided another powerful reason for rejecting the losses that were claimed. I don't think we need to go back to the authorities, but because my lords will be familiar with it's the same passage.
Well, could you just give us a proposition which you're going to make good?
So there are two propositions that I take from Kuwait Airways. The first is that when considering legal causation, you have to consider the reasons why the law has recognised the cause of action in question. And the second is that I say that Lord Nichols set out a structured approach to the difficulties that arise on a case like the one before the court, which was to examine the sequence of events leading to the plaintiff's loss and identify the happening or happenings which should be regarded as the cause of the loss for the purpose of allocating responsibility. So one needs to look at the whole chronology and ask the question, given the nature of the causes of action that are engaged, where should this loss really sit?
Right, well that takes us so far, but what more should the judge have done?
So what the judge ought to have done was to focus on the cause of action, the causes of action that were engaged by the facts of the case, and carried out an assessment of the sequence of events in light of that focus. So as to the nature of the cause of action, we've already considered the nature of patent infringement in the UK, and the statute's purpose is to enable a patentee to exert control over the markets for manufacture and distribution of products within the territory of the UK. But in this case, the key events, manufacture and distribution, took place overseas. And that means that questions of UK patent policy and UK patent causation fall to be considered in the context of overseas patent statutes, and in particular the patent legislation in China, the Netherlands, South Africa and North Macedonia. The patent statutes in those countries bear on the question at hand, which is what were the important acts for the purposes of the loss of profits that are asserted here. And they all sing from the same hymn sheet on this question. Just like the UK Patents Act, they allow a local patentee to control the manufacture and distribution of product within their national boundaries. And as a secondary matter, they allow the patentee to prevent the importation of product into their territories. Now, we do have the text of these statutes in the bundles, but I don't think we need to go to them if you are happy to take my summary of them in those short sentences. And if one then considers the sequence of events leading to the loss in issue in the context of those materials, well, the losses in issue relate to sales that Rhodia say they would have made on the cerium oxide markets in the Netherlands, North Macedonia and South Africa. They say those sales were wrongly displaced by sales of Neo C100N product to JM entities in those countries. Now, if Anan Kasei had valid counterpart patents in those countries, those sales of C100N would have infringed those counterpart patents, and the losses would have been directly recoverable. There would be no arguments about chains of causation or scope of duty, proportionality or trade barriers. So local patent infringement represents the best candidate cause of action for the losses in issue. What about the second best candidate event? Well, that, we say, would be the non-infringing importation of C100N into the Netherlands, North Macedonia and South Africa. That's another infringement of the local statutes. The third best candidate is the manufacture in China. As we've discussed, all the C100N that was sold onto these overseas markets was manufactured in China, and that manufacture would have been an infringement of a valid Chinese patent. And again, such infringement would unquestionably be a more effective, more proximate, more substantial cause of the losses in issue than the infringement of the UK patent. And that really is the point is as simple as that. It was something for the judge to weigh when she considered legal causation, and she decided that it wasn't necessary to do so.
I'm obviously only speaking for myself, and this may be very interesting, but could we just alight before we go any further on your pleading at this point? Because having looked at your skeleton argument, it only touches upon what the judge actually did at one paragraph. The grounds annexed to the respondent's notice, we find at 235. Bottom of the page, is that so? Point 3.
Yes.
Well, I mean, it just strikes me that it's a sort of impressionistic argument that the judge might have written a slightly different judgment.
Well,
I mean, before we spend even 45 minutes on this, I want to understand that there's really some point to this,
yes,
rather than that the judge might have accepted a few of your arguments which he didn't.
Yes. So there is some point to it, because this isn't just about, well, the judge didn't give as much weight to the argument as I was inviting her to do. She gave no weight to it. And that, I say, is contrary to the obligation to take account of the cause of action. She didn't take account of the patent flavour of the claim when assessing legal causation, because she interpreted my argument as one which inevitably would succeed in all cases, as opposed to one which had to be interpreted against the facts of the case.
Right.
On that basis,
so
she said,
we'll call it the patent flavour argument.
my lord,
Can you take us in short order then to the judgment to show where she dealt with your patent flavour argument, assuming it's a good one?
my lord, I can.
And why it matters so much that she didn't accept it? Yes,
indeed. So it's paragraph 161 of the judgment.
Just paragraph 161.
Just paragraph 161.
Read it again. Right. Now, what is it that she misunderstood? Firstly, your argument?
So I think she took my argument to be a binary, black or white, that once you've alighted upon, once you have an overseas patent, you cannot recover any losses in any situation. And then she played the Gerber and Lecturer card against that, say that can't be right. But the argument was one based on the facts of the case. It was more nuanced than that. It accorded with the guidance in Kuwait Airways and since Kuwait Airways that legal causation has to be assessed in the context of the cause of action, and that in the context of this cause of action, it was of real significance that the sales in issue took place where patents were available overseas, and the manufacture in issue took place in a place where patents were available overseas. And therefore, I say she should have said, well, this is not a trump card for Mr. Cadogan, but it's a matter that I will give some weight to. And when she came back to the assessment in paragraph 185 and following, there should have been another factor there, which is that the overseas losses had a much closer connection with other potential causes of action which were available.
But isn't this really the repackaging of your responsive arguments on causation, and indeed quite a lot of what you've been telling us already this morning?
Well,
but I'm just not seeing that this really adds much value to your argument.
My lord, so be it.
But I'm saying so because not because I've reached any valid view on it, but simply because I don't want to spend time just simply trawling through the history that we all know about.
My lord, I've taken the
in
point.
order to not make any difference.
No, I have taken the point at some speed, and I'm going to move on from it. But in a nutshell, my complaint is the reasoning upon which the judge gave the argument no weight was not applicable. The authorities required the judge to give the point some weight, and she did not.
Right. Well, that I perfectly understand that as a point, but I'm not sure that it's going to take much garnishing.
Yeah.
Could I just check that my lords don't take a different view?
Very well.
If you're content with that, we've absorbed that particular point, and as usual, they're always much better when they're shortly made.
Well, in that case, it was an excellent point, and
Yes.
I will move on to...
Well, you'll probably not say anything at all in that case about number 4.
Unfortunately, I do have to say something about
All right.
Respondents' Notice 4, because quite a lot of money might hang on it, and there is a simple, discrete problem with where we got to on that.
Right, now, while we're in the judgment at the moment, does this link particularly to a judgment paragraph that you're going to come to? So we can just have that in sight.
Yes, you could turn forward to... So, I think it's probably paragraph 266 is where it starts. So there's a discrete problem, a well-constrained problem here. The judge held that on the facts, the appellants, or Rhodia, did not have capacity to produce before 2018, and so she instead awarded, or would have awarded, licence fee damages. And the licence fee damages claim was unusual in that, again, it was not a very ambitious claim. The appellant said that a reasonable party in Neo's position would have agreed to pay worldwide royalties on sales of cerium oxide in consideration for a licence just for the UK patent. So global royalties for a local licence. And at the same time, they said that in the counterfactual world where Neo had this licence, they would have charged much higher prices to Johnson Matthey. In particular, they said they would have charged Rhodia's prices, which were much higher than the price Johnson Matthey actually paid to Neo. And Rhodia then said that Neo would have agreed to pay a very high proportion of those prices to Rhodia to obtain this little local licence. Now, the judge held that the global royalties for a local licence was an arguable claim in circumstances where that local licence acted as a gateway to global sales. And as we've discussed, because of JM's testing facilities, it did act as a gateway. So we don't challenge that finding on this appeal. She then rejected Rhodia's case that Neo would have charged higher prices to Johnson Matthey in the counterfactual world of the notional licence. She said the price would have remained the same, and neither party challenges that finding. And we accept that in relation to dealings between Neo and Johnson Matthey, the real world reflects the notional world, in that in the real world, JM bought a product at risk because we couldn't give them a licence, and that's the same in the notional world, because the notional license can't be sub-licensed. The problem came with the judge's assessment of the value of this local license to Neo. That was an issue because under the local license, Neo was manufacturing at risk. It didn't get a license under the Chinese patent that was extant at all material times of manufacture. So all those acts of manufacture could have been prevented by the Chinese patent. And it was common ground at trial, and remains common ground, that the notional license didn't give a license under the Chinese patent. And the evidential problem which arises, it comes because the valuation evidence given by the expert accountants addressed a notional license which included a license under the Chinese patent. In other words, it gave Neo freedom to operate worldwide. Now, there was a good reason why the experts took this approach, because it would be commercially eccentric for Neo to pay for a license that allowed it to distribute in the UK, but not to manufacture the product that would be distributed here. The evidential problem could have been overcome if there was a principled basis for adjusting the global license that the accountants had valued to reflect the local license that represented the case considered by the judge.
Sorry to break up your flow, but I'm afraid I've lost the thread here. Could you just help me in explaining what the sequence of decisions on the issues would have to be in order for this point to become
yes,
a live point? Could you just run through?
Absolutely. So the appeal has to succeed on legal causation.
Yep.
And then I lose on my territorial scope of duty.
And one fails.
And I lose on, well, I lose on 1, 2, and 3 in the respondent's notice.
Right. The appeals succeed and all the other ones for which permission have been granted fail.
My lord, yes.
So this is, in terms of the grounds that have been permitted so far, this is, as it were, the last-ditch argument, because by that stage, all other bridges have crossed.
If you will. I mean, grounds 1, 2, and 3 have quite a degree of commonality, and this is a particular complaint about one of the two parts of the damages award that the judge contingently assessed.
Right, and it's to do with 2015, 16, 17, is it?
My lord, yes.
And is it paragraph 274 that is the decisive paragraph on this point?
No, the decisive paragraph is actually probably 295.
Okay. 295.
Yes.
Thank you.
But it may help if I lead into that.
Yeah, well, just taking it shortly for the moment while I'm doing an aerial view.
Yes. So what?
Right. So is the argument about what end of the range is involved?
No.
Well, so if you got to the point where you needed this
Yes.
argument, what do you say the consequence of your succeeding on it is?
The consequence of my success on this argument is that the Rhodia cannot recover damages up to the end of 2018 because their license, they didn't have evidence to support their license fee claim.
Right. So
To the end of 2017.
At the end of 17, yes, understood that. In a sense, therefore, it's a complete defence to those years of claim.
My lord, yes.
And what is the alternative? Is the alternative what the judge has said at the end of 295?
I think in terms of what's before, not quite sure what you mean by the alternative.
Well, that I'm just anxious to understand, this is a binary matter, is it? That
I think
either the judge's conclusion, which is that they get an allocation at the top end of the range, stands,
Yes.
because it's not in specific issue, or nothing.
I think that probably is right, given the nature of my complaint.
All right. So that is helpful. And do you want, before you go into more detail, just to tell us in a nutshell, what is the essential reason why the judge was wrong to reach her 295 conclusion?
So the essential problem is she had expert accountants who valued a global license. And then she had the law which says, with common ground, you just need a local license, right? You need a UK license. You've got to value a UK license. That UK license was an eccentric proposition for a licensee who was only interested in manufacturing in China, which made them moving from one to the other, rationalising the move from one to the other, an irresoluble problem. The experts couldn't do it, and the basis upon which the judge did it can't be defended. And it all comes from the fact that there's a sort of there's almost like a divide by zero error in the claim that was brought. Who would sign up to a license that allowed them to distribute in the UK but not make the product that they wanted to bring?
You're saying that the judge is performing an irrational exercise?
Well, it's only really the last step where she tries to adjust the local license to make it, adjust the global license terms to fit the local license that was in issue, where she made a step which we say is indefensible on the evidence.
Thank you.
Yeah. So the problem is identified by the judge at the start of this section of her judgment at 266, because the pleaded case, consistently you say with the law, is that we're talking about a UK licence. And the problem was that Mr. Besant, who is Rhodia's expert, and indeed Mr. Bolton took the same approach, your expert, had valued a global licence, giving Neo worldwide rights to manufacture and sell CN100, including, in particular, in China.
Yes.
So there was, on the face of it, a mismatch between the pleaded case and the expert evidence.
Yes.
And so the judge recognised that problem, and the question is, was the way in which she attempted to solve that problem correct or not?
My lord has the point. And there are, I can move swiftly on that basis, or I can take it more slowly if you would like me to.
No, that's been very helpful. Thank you. You can go forward as best you like.
I'm grateful. So on the evidence, it wasn't simply that Mr. Besant accepted that he didn't have the information to adjust his global license to reflect the local license. Mr. Bolton's position was slightly more forthright. Perhaps I could just show you his report on the point very quickly, because it was unchallenged evidence.
Well, is it different to what the judge says about it? Because
yes, it is.
There's more in it than is in the judgment.
There is more in it.
Very well. Where do we go?
So it's a supplemental bundle, tab 24.
Remind me which side Mr. Bolton was on.
Mr. Bolton was for Neo, my lord.
Thank you. And the page number was to...
Page 170.
Thank you.
And if we start at paragraph 5.2.2, that refers to the fact that the notional license, Rhodia's notional license, does not cover the manufacture of C100 in China or the supply of C100 to JM outside the UK. And then he gives his comments at 5.2.4, and it's the first two paragraphs that are particularly important. So first two subparagraphs, excuse me. At one, he says that the notional licence would not prevent Rhodia from objecting to the manufacture by Neo of C100N in China. It's common ground he's right about that. And he says that such objection would frustrate the objective of the notional licence. And I think that's also accepted. And then at 2, he says that an agreement along these lines is not commercially rational. The licensee is merely buying the chance of freedom to operate. And Mr. Bolton can't value that licence in the absence of some basis for estimating the chance. So his unchallenged position was that Rhodia's licence claim amounted to a gamble in which no information had been provided about probability. So he couldn't do the exercise. So in summary, the common position of the experts was that an adjustment needed to be made to reflect the risk associated with the Chinese patent, and neither of them had the information that would have been required to estimate that adjustment. And in addition, Mr. Bolton, who was one of the most experienced IP valuation experts of his generation, gave unchallenged evidence that the appellant's claim was not commercially rational. And then I can show you how the judge sought to resolve these difficulties. And as my Lord Justice Arnold has pointed out, at paragraph 266, she recorded our position, which I believe she accepted was accurate, that Mr. Besant had valued a global licence. And then under paragraph 279, she sets out a passage.
Well, 273 identifies the very point you told us that we had to look at the report, but I've got that from 273 of the judgment.
Yes, I don't think there's a reference there to the commercial irrationality that Mr. Bolton said was...
Neo objected would not have been commercially
Oh, I'm
rational.
so sorry, I misread that. My
right.
Lord, I do apologise.
So there's the point.
Yes,
in 273 of the judgment. So the judge is alive to it.
Yes, my Lord is absolutely right.
And then we went to where?
Then 279, this is the part of the oral evidence of Mr. Besant that I was just referring to. There are some earlier relevant passages as well, but at the end, he summarised the position that they do not get, under your notional licence, a right to do that. Then this licence is of nugatory value. If they do not obtain the rights they need to do that, this licence is of less value. How much less, I cannot tell you, because I do not know about the rights they may need. The rights they may need, those are the overseas patents. And then at 280, the judge records the position up to now. It follows that in the present case, any valuation of the notional licence would have to take into account the existence of other patents held by Rhodia, and in particular the Chinese patent. That is entirely correct. The difficulty comes in trying to do that, and the learned judge does that in the passage beginning at paragraph 290. The heading is percentage of contribution margin that Neo could expect to obtain. We think that might
It's
be...
282. Pass muster.
Well, so we accept at this stage that it's sustainable in principle if there's evidence that can value it.
Right.
Yeah, your point is there was no evidence.
My Lord, yes. There was evidence of a different licence. You couldn't bridge the two, and the judge's attempt to do so was wrong in principle. So the meat of it begins on paragraph 290. And as I said, the heading, it might be better understood as percentage of contribution margin that Rhodia could expect to obtain, although Neo would, of course, be paying it. So, and she says at 291, Mr. Besant and Mr. Bolton agreed that literature and practice identified an allocation of between 25 and 50% of incremental benefit to the licensor. But those were both global license numbers. So they need to be there needs to be a basis upon which they can be applied to a local license. No one said that 25% was the bottom end for a local license, 0% was the bottom end for a local license, because if the Chinese patent is valid, the whole trade is imperiled. And then she records that Mr. Besant gave reasons why a global license for cerium oxide might be towards the upper end of the range, and Mr. Bolton gave reasons why it might be towards the bottom end of the range, but neither had said that this range was applicable to the license in issue. The judge then proceeds to resolve the dispute between the experts on these global license terms, and she rejects one of Mr. Besant's points, exclusivity, and one of Mr. Bolton's points, alternative products. That's paragraph 293 and 294. And then in the middle of 295, the judge inserted a reference to the Chinese patent problem. Second sentence, Rhodia would have remained in the market as a competitor with the potential to increase its capacity over time, and with Neo continuing to bear a litigation risk as discussed above. That litigation risk was foundational, and it needed to be quantitatively addressed as a matter of evidence. And it wasn't. She doesn't provide any quantification for the adjustment that needs to be made to reflect that factor. She then alights upon 35% as the applicable rate. So in summary, we have 4 complaints. First, this analysis, or rather the calculation, proceeds on the basis that a 25% royalty was the lower boundary for the notional local license, and there was no evidence for that. Indeed, the evidence was to the contrary. Second, it proceeds on the basis that the court had the information needed to adjust the price for a global license so as to reflect the value of a local license, when in fact the experts were agreed on the contrary proposition. Information was needed which they did not have, and that complaint is fortified by the outcome of the judge's assessment. 35% is the geometric mean of 25% and 50%, so it does rather appear that she has addressed the insuperable problem by not taking account of it. Third, it ignored Mr. Bolton's unchallenged evidence that on the information before the court, the notional local license was not commercially rational. License fee damages, of course, represent a fair payment for the rights in issue, and a payment which is objectively commercially irrational cannot be fair. If the appellants wanted to maintain their pleaded license claim, they had to challenge Mr. Bolton's position on that point. And fourth and lastly, the judge's license did not reflect the term of the infringement. That's a requirement for license fee damages as established by the Eaton Mansions case in this court. The last infringing activity was in July 2017.
That seems to be a rather separate point.
It is a separate point, yes. But it was an objection we maintained at all times, and it's not one that's been addressed.
So, just to be clear as to what you've just said, your complaint there is that the judge hasn't addressed that argument at all.
Yes. And if her license is open-ended, then it contravenes that principle. Obviously, it can be...
But why would it be open-ended? I don't understand that, because the judge is only awarded what I would prefer to call a reasonable royalty in respect to the period down to the end of 2017.
Yes. So if it finishes in July 2017, then that's...
well, the difference seems to be 6 months.
Indeed. It's a point of detail, my lord. I wouldn't want to take more time on it.
Right.
It had more impact below when the capacity question was at large.
Okay.
Because we remind ourselves that we're only in the royalty box because of the capacity findings.
Very much so, yes.
Understand?
My lords, I've managed to finish those 2 points a little quicker than I had hoped.
Very much.
And the question arises whether you would rather hear from my learned friend on those the bigger points of principle while they're fresh, or whether you would prefer me to go ahead with the disclosure and other elements now.
Can I ask you, Mr. Mitchison, whether you have any view about that? I can see that there's some attraction while we have this in the forefront of our minds, but we don't want to obstruct a better way. If you can see one.
Well, I'm obviously content to respond to my learned friend now, if that's more convenient to your lordship.
Yes, and do you have, I mean, roughly speaking, how long are you likely to need to deal with those? Now I think pretty much 3 respondent notice points.
Yes, I think I'm bound to take the rest of the day.
Oh, for sure, yeah.
And then a little bit of time tomorrow morning.
Thinking about it, I think there is some merit on this. I wasn't sure to begin with. And I think the merit is this, that all the remaining points are about the exclusive licence question. And that really is distinct subject matter, isn't it?
It is.
Yeah.
All right. I think as we what we'll do is take a slightly early 5 minutes now for the benefit of the transcriber to allow you to gather your forces, and then we'll look particularly, obviously, at RN1 in some detail with you. Thank you.
Okay. You've only got another 6 years.
At least my checkbook doesn't have to be open too wide yet. I get the impression that's exponentially increasing.
Do you know what? Some of these problems. How was the traffic? There was very little when I came in.
Nothing. Well, I set up a little bit later, so it was 5:30.
Could have set up this late. It would have been fine. I mean, no, I'm just saying, mate. It's
Probably
amazing.
could have done it
Thanks.
later.
It was amazing how you got on that. So,
All right.
I can pass
I'm not sure
train
what
strikes.
Yeah.
Put the cars in. Now they just don't go.
Yeah, I don't think people will have to work. Well, I set up at 5 o'clock yesterday, 5:30 today. I'll go for 6 o'clock tomorrow for second exams.
Many people are holding themselves along the railing.
Yeah. That's the fear. It's that snow layer and then freezing. I was like, -4.
Because of the roads.
Heavily gritty roads. No, that's part of the service I'm offering to my leaders. Is a drive up the hill with this bike in the back of my car each evening. Try and make sure I'm kept alive the next morning.
Thanks, Rose.
You're back.
I'm grateful. So starting with Respondents Notice point 1, and as you will understand, Rhodia supports the judge's judgment under this head for the reasons she gave. She was correct, first of all, to doubt whether the concept of scope of duty in the tort of negligence can readily be transposed to patent infringement. To the extent that there is a requirement to look at the statute, she was correct to observe that the Patents Act does not circumscribe the scope of damages recoverable. That's her observation in paragraph 90. And therefore, she went ahead to apply general tortious principles. And we say she was correct to conclude that general tortious principles do not exclude the sort of loss for which compensation was sought here. Now, we've already looked at Gerber and Lectra in the Court of Appeal, and in particular, Lord Justice Staunton at pages 451 to 456. And we say that the judge in this case correctly summarised his judgment in her paragraphs 93 to 96, in which she determined there was no limitation in the Patents Act. The Patents Act is aimed at protecting patentees from commercial loss resulting from the wrongful infringement of their rights. There's no distinction drawn between profit on the sale of patented articles and profit on the sale of convoyed goods, and there is no rule of law emerging from any previous case law which should limit the damages on convoyed goods so as to exclude the extraterritorial losses that we sought to claim here. Now, in doing so, she was presented with the same two cases that my learned friend took you to this morning, Patterson, Zakonis and USP. And if I can just pick up a couple of points from each of them, I won't try not to go over the material my learned friend's already shown you. Firstly, in Patterson, Zakonis, which is in Joint Authorities 1 at tab 3. And my learned friend focused on the decision of Lord Justice Goff, as he then was, but we also draw attention to the decision of Lord Justice Oliver, and the passages which I wanted to draw to your attention.
Sorry, I can't. I was looking at the head note for the first time, seeing that it's skin cream under the name of Venus de Milo.
Indeed.
Very curious choice.
Yes.
Where are we?
Indeed. So I'm going to pick it up on page 40 of the bundle. And this is Lord Justice Oliver, where he was summarising the position before the Court of Appeal. This is an interim or interlocutory appeal, this one was. And then in the middle of the page, he summarises, thus the action is in effect an action for damages for passing off without any allegation that the defendants themselves passed off or been knowingly privy to passing off the plaintiff's goods. Indeed, that was expressly disclaimed in the argument before the judge. So although clearly there was an allegation of passing off against the original people who had asked the printers to do the copying, it was not alleged that the defendants, the printers, were joint tortfeasors or involved in the passing off in any way. And so he went on, if you flick on to page 43, and what Lord Justice Oliver, he dismissed the arguments for the sake, just as Lord Justice Goff did, but he summarised it like this, just in the first full paragraph, middle of the page on 43, although he rejected some of the arguments of Mr. Baldwin, he says, on the other hand, it does not at all follow in my judgment that the statutory right to recover damages from one who unwittingly infringes a copyright extends to the recovery of loss which may be caused by the use made by a third party of the infringing material. And if I could ask you please to pick it up at the bottom of the page where it begins, what the instant case is concerned with. Did your Lordship see that about 8 lines up? And if you would read please to the end of the first full paragraph on the second page, please.
Yes.
And so the points we highlight from there, and again, I think my learned friend did take you to this one sentence, certainly in that level with the top hole punch, what Justice Oliver said, that the claim includes damages for the invasion by a quite different person of a quite different right, namely their right to the goodwill and reputation of a business. And then he goes on to say, effectively, this is a duty of attempt to argue a duty of care, and he goes on to then dismiss the claims for negligence. And so we say that that is to be distinguished with the position in the present case where it is the same person who we are alleging, or we're saying the damage flows from the acts of the same person, that is Neo, and is not a different right, it's the same right, but these are damages flowing foreseeably and naturally from the patent infringement that took place. And so we say that the findings of the Court of Appeal in this case just don't apply. And if you go on to page 48, please, this is Lord Justice Fox, and again he expresses it, perhaps I could ask you to read from the bottom of 48, the present case is quite different to just below halfway down on 49.
Yes.
And so again, he was emphasising the difference in the type of loss and the fact that it involved a third party. Here we see that the losses, they're the same type of losses as against the same party, and they all flow naturally, foreseeably, intendedly, expectedly from the acts which all took place in the United Kingdom. And so we say the distinction is there, it's plain and obvious on the face of the difference between the cases. And of course, this was a case that was looked at by Mr. Justice Jacob in Gerber and Lecturer, and also Lord Justice Staunton. So it's already been through the mill, and they rejected it as applying to convoyed goods, in the way that they did in Gerber and Lectra, and we say it can't be any better a fortiori in relation to convoy goods which just happen to be sold abroad, as in this case. So for those reasons we say it just doesn't assist, and the judge was right to reject it. Yes, yeah, and it's in Gerber and Lecter, it's Lord Justice Stilton at page 455 of the report, where he addresses 1.49 of the bundle, and it was Mr. Justice Jacob addressed it. It was the passage I skipped over when I took you to it. Page 82 of the bundle.
Yes.
So that is Patterson's Aconis. And of course, we do continue to rely, as Lord Justice Gough pointed out, the damages for infringement of copyright under the Copyright Act of 1956 was the depreciation caused by the infringement to the value of the copyright as it shows in action, and that again is different to the damage that is awarded under the Patents Act 1977, which is a further difference with the present case. Then we go to USP, which is in tab 10. And I don't think I need to spend very long on this, because I think the points I wanted to make probably came out of the discussion that my learned friend has already had with you. And as my Lord Justice Coulson pointed out, in the end, this case is very straightforward. It was held that the damages were not caused by the infringement of the copyright. It was only the idea that had been taken to cause the damage, and therefore it was right that damages should not flow as a result of that. Lord Justice Jacob perhaps characteristically summarised it most succinctly on page 379 of the report, and which is really consistent with the discussion had earlier. Perhaps I could just refer your lordships to that.
Yes.
So again, we say that he can't assist, and the judge was right not to place weight on it. Instead, the judge did place weight on a number of authorities which she reviewed, English authorities or British authorities, which she reviewed paragraphs 98 onwards. And we say that those, she was right to find support in them, even if the comments were generally obiter, but they were nevertheless supportive of her position and rightly bolstered her. Probably as time is not, we don't have that much time, I'm not going to take you to each of them, but we do say that they do support the judge's findings. I was going to highlight a couple of them, if I may. Firstly and briefly, there is the Bayer and Charles River decision in tab 13 of the bundles.
Can we just anchor ourselves in the judgment?
Yes, sorry, this is in, she refers to this in 103.
Right, well, it'd be helpful to read that first. Is there some echo of the circumstance of this case in the circumstance of that case?
Indeed, and that's why I accept it's only first instance, of course, and it's a case in Scotland, so I can't place too much weight on it. But it is a case where there were activities taking place in the United Kingdom which enabled the defendants to get a licence to sell abroad, and in that case, the judge held that it wasn't. That didn't preclude the grant of springboard relief, even though those sales were abroad. And the reasoning given by the judge in that case is consistent with the reasoning of the judge in the present case. And so that's why we say...
I'm sorry, I interrupted you when you were telling us that it was at which tab?
It's tab 13.
And what part of this
So
opinion?
you see that, I mean, the judges, as you have already noted, summarised the facts about the testing in the UK for use outside. That's in paragraphs 2 and 3. And then the discussion begins on page 468, bundle. And we see that the usual argument made by the defendant, oh, well, the sales were lawful acts, and should that preclude relief being granted? And the judge says about level with a second hole punch on 468, says in themselves the sales may have been lawful acts, but to my mind it's far from obvious this automatically severs the chain of legal causation. The suggestion made on behalf of the second defendant that it might have been open to obtain the advantage of another on other non-infringing ways cannot allow attention to divert it from the admitted wrongful conduct and its direct consequences. And just above, sorry, I should take you to just below the first hole punch, the judge notes, this is all the more so, this is whether you can derive a remedy, when the basic purpose of the remedy sought by the pursuer is to deprive the infringer of unfair or unjustified profits.
Sorry, I'm a bit puzzled by that statement. Was this a claim for an account of profits or a
It
claim?
was, this is an account of profits.
Oh, right, okay. Well, but, sorry, if we're concerned with an account of profits, why is this of any relevance at all? An account of profits is not a remedy, compensatory remedy like damages. It's a remedy by way of unjust enrichment.
I accept that
It proceeds on an entirely different philosophical basis.
I accept that there may be differences where an account is sought, but there was nothing. The springboard relief that was sought was not objectionable for the reasons the judge gave.
Right, and he refers to the authorities being well settled. That's about other non-infringing ways.
Yes, I think that's
All right.
I mean, there's no dispute between us that there isn't a case right on point that the judge missed.
All right.
In this, that may be because there are so few inquiries in different cases. So it's something that we've done previously. The next case I wanted to take you to was Smith and Nephew and Convatec in tab 17. Just check. And this is just in relation to my Lord Justice Arnold's point, that the statute, of course, is the provision which allows recovery of an account of profits is worded similarly to the provision that allows recovery of damages. It's an account of profits.
But I'm sorry, as I'm sure you appreciate, Mr. Mitchison, it's fundamentally different. When you have a claim for damages, you are compensating the claimant for the damages that the claimant has sustained by reason of the infringement. Hence you have, first of all, the factual causation inquiry, and secondly, the legal causation inquiry. By contrast, when you have a claim for an account of profits, what happened to the claimant is utterly irrelevant. The claimant could and frequently has suffered no loss. That's precisely for that reason that the claim for an account of profit is made. And what you are looking at is the profits made by the infringer.
But that might cover otherwise lawful acts, which it did in fact in that case. The acts of selling the insecticide in the United States were lawful under US law, but that didn't mean that the profits couldn't be disgorged. Now I accept, of course, equitable principles might apply to
But
allow...
it is undoubtedly an equitable remedy, yes.
Yes, but the principle of recovering for otherwise lawful acts, there is a parallel between the two positions.
Yeah, okay, I understand, thank you.
Yes, Yes, and that was one of the submissions the judge had to deal with in that case. That it was a lawful act, so we shouldn't have to disgorge. Smith and Nephew and Combatech, that is at tab 17, 562, and this is the judge dealt with this in paragraph 102 of the judgment. Perhaps Your Lordship would just remind yourselves of that.
I think that's a wrong reference.
I'm sorry.
You said 102?
102 of the judgment is where the judge.
Oh, sorry,
Yes.
the judge at the present judgment. Right, sorry, I thought you were referring to Smith and Combatech. Yeah.
And in the judgment itself, if we start off at, this is Smith and Nephew, at tab 17, start off at 587. And again, the facts of that case are not dissimilar to the present case. So if Your Lordships look at 112 of that case, what happened is, in that case, Smith and Nephew applied for a CE mark for their product. That was granted, and the product made by using the non-infringing process is also covered by the existing CE mark approval. And so therefore there was activities derived from work in the UK that covered activities throughout the rest of Europe. And the question was whether relief could be granted in respect of that those broader activities.
Yeah, but as one can see, it's a classic springboard claim because the argument is that the infringer has got on the market earlier by reason of the infringement
Yes,
than it would otherwise have done.
indeed, but it does also cover the concept of granting relief in relation to acts which are otherwise lawful, and that's why we say that there are parallels. So, Mr. Justice Burse reviewed the law in some detail, and this point arises particularly in top of page 588 in paragraph 117. He says, often the act restrained by a final springboard injunction would otherwise be lawful. If the act's restrained would be unlawful anyway, then no conceptual difficulty arises. The interesting question is whether and in what circumstances the court should grant a final injunction which restrains what would otherwise be a lawful act. He deals with the argument that that should never take place in 118, and that was dropped. Then he goes on to review the law in relation to springboards, and he starts at 121. And perhaps I could ask Your Lordships to read paragraph 121 first of all.
Yes?
And so the reason this is also relevant to the Respondents' Notice 2 point, which is why I light on it now, but as a principle of European law at least, the Court of Justice decided that the grant of an injunction post-expiry of the patent in the Netherlands was not contrary to Articles 30 and 36. And I accept that they weren't obviously construing patent law per se at that stage, but in doing so, they didn't say that there were objections on the grounds of proportionality or an impermissible barrier to intra-community trade. And so we say that decision is exportable to the issues arising under the Respondents' Notice 2, and it's also of note that grant of relief to prevent otherwise lawful acts are not in breach in principle of European law. We say that is consistent with the judge's findings on this extraterritorial forum point. Then the judge went on to review some other cases, including at 127, one of the Amgen cases. And again, there were parallels between the facts of Amgen and the present case, where there was a question about whether infringing acts, which had been allowed to get the benefit of European regulatory approval, could be injuncted, and therefore delaying entry into the market on an otherwise lawful basis. And perhaps Your Lordships would just read the judge's summary in 127.
Do you mean 127?
127 of Comitech. Sorry,
No, I'm sorry. Yes.
Then, and of course, this is Justice Newberg, as he then was in Amgen. Then we have a judge reviewed one of his previous decisions in Merck and Sigma. That was another case where he granted a springboard injunction after the expiry of a supplementary protection certificate, and he had held that to do so was justifiable because, as he puts it in 129, the court will intervene to deprive an infringer of an unwarranted advantage gained from their act of infringement. And then finally, while we're here again, it's helpful to look at what he said about the enforcement directive and whether the sort of relief we're talking about here, relief for otherwise lawful acts, would be contrary to it. And can I just ask your lordships to read 130 on that?
Yeah, well, we know that the last sentence is flat wrong.
Well, I was at the moment I'm really addressing the previous sentence where he says, well, if damages are in principle recoverable based on Gerber, he doesn't see why an injunction shouldn't also be granted. And of course, we put it the other way around as well. We say, imagine that we had got an injunction in this case, and we had prevented Neo from carrying out any of the activities which infringed in the UK, in which case, as the judge found, Johnson Matthey would never have approved the material, and Neo would never have made the sales to Johnson Matthey in Macedonia and South Africa. In which case, none of the profits would have been made by Neo. Rhodia, as the only other player in the market, would have had the entirety of the market. So if an injunction would have resulted in Rhodia being compensated in the way that Rhodia seeks in this action, and that injunction is lawful, why, if no injunction...
That's reversing Mr. Justice Burse's logic.
Because
his logic is, if you can get damages, then why can't you get an injunction to stop the damages being incurred?
Yes.
Whereas you're trying to reverse the logic.
Yes, because I'm relying on some of these other cases which look at the grant of springboard relief and injunctions to prevent otherwise lawful acts.
But one's got to be a bit careful if you start reversing the logic. I mean, one of the concerns that arises in springboard cases, I don't think it's relevant for our case, but it just illustrates one where's got to be a bit careful, is that the risk of a springboard injunction is that the claimant is put into a better position than if there had been no infringement at all, which clearly can't be right.
Yes, I accept that my own friend put it that way this morning. He said, well, the danger of the injunction is you effectively get the but-for relief that you wouldn't get if you had done a proper damages inquiry.
Yeah.
Now, that there may be circumstances in which that arises. I mean, imagine if you injuncted the doctor from giving advice, the mountaineer would never have had his knee approved and he'd never have gone on the trip. So that's suddenly the counterfactual is different. But here, of course, the counterfactual and the judge's findings show that there was no alternative for Neo. If they didn't do the infringing acts in the United Kingdom, they would never have got the sales. And so there's no extra benefit gained by a putative injunction in this case, as opposed to the damages we now seek. And if, based on these cases, and any, I mean, it would be an ordinary, there would be no springboard, no extra legal relief granted in this case, just to stop Neo doing the acts they were doing in the UK. And if that would have allowed Rhodia to recover all of the profits that it sought under this inquiry, then we submit that it shows the judge was right to consider that damages are also recoverable.
Just moving into a slightly more general mode, as I understand your case, that you can point to a number of instances in this area,
yes,
in which judges have been prepared to contemplate extraterritorial action. There are no domestic decisions to the contrary. And therefore, the respondent, in this case, has to go to the minority decision in Western
Yes, Western GCO.
GCO.
Yes. And
So, I mean, does it go any further than that in the end?
it doesn't. I suppose the benefit of looking at some of these cases.
No, I understand. I'm not complaining about it, but in a sense is that, I mean, we have to form our own view about this, but a range of people who know a lot about these things have taken this view. Nobody, whether they knew a lot about it or not, hasn't. Has taken a contrary view. And as against that, we have Justice Coulson.
That's correct, my lord. That's how we see it. And so it's the fact that there are eminent people coming to the view that the judge came to. The reasoning that they come to is consistent with the reasoning of the judge.
Well, in one sense, bearing in mind the respect that she has to pay to her colleagues' decisions, and the absence of any appellate authority on this, it would have been quite difficult for her to have reached a different view on this. She had a particular reason to do so.
Yes, and the only basis that was put to her was really Justice Gorsuch in Western GCO.
Yeah.
All right. Maybe I can take it a bit more quickly. There's one other English decision I was going to show you, which is the HTC decision. And the only reason I alighted on that, I thought I would keep it in my note at lunchtime, because it does deal with the sort of situation that your lordship, Lord Justice Jackson, put to my own friend this morning. So this is tab authorities 3, tab 28, and this was referred to by the judge in paragraph 98 of her decision, and it's actually a different passage I want to show you, if I may. And so Mr. Justice Burse again, and he deals with a point of principle on page 921 of the bundle at paragraph 11. And then he goes on to deal with an example close to the one your lordship put to my learned friend this morning in paragraph 38. I accept in this case Neo are not actually manufacturing in the UK, but the gateway activities that they did carry out in the UK, we say are consistent, that they were, the foreign sales in this case, were caused by the infringements of the UK patent for the reasons we've already been over. So we say that is all consistent with the judge's findings. The only other point I think to make on this before I turn to Western GCO briefly is we did show the judge an article that reviewed the position across the rest of Europe, and she didn't refer to it expressly in her, or didn't refer to it in her judgment, but it again provides comfort in our submission to the fact that it's not. The United Kingdom is not going out of line in allowing relief to prevent otherwise lawful acts in the right circumstances, and that is at tab 36 of the authorities bundle.
I thought she did refer to one of your articles at 106. There's a Cotter article which I was going to go to. This is an article that's about the US position. This was an article by some
solicitors at Wilmer Hale, one of whom's now gone back to Burnberg, but as it may, reviewing the position across Europe. So the article begins at 1081, and at 1083 they note a German Supreme Court case where copyright infringement damages for overseas sales were recoverable, in the left-hand column. And then in the right-hand column on 1084, they note that the UK Supreme Court suggested that copyright damages might be available for foreign sales in the Star Wars helmet case. Actually, we'll just look at the quote from the Supreme Court on page 1084. And then finally, on page 1086, the authors in the right-hand column note that the provisions of the unitary UPC, which is meant to be starting next year in the EU, also does allow extraterritorial relief, which would otherwise cover lawful acts, and that again is consistent with the position the judge took, and consistent with the position that this sort of relief is allowable under the enforcement directive.
Yes.
So finally, that brings us to Western GECO, and again, unsurprisingly, we say that the majority were right in Western GECO, not Justice Gorsuch. We tried to draw, or we seek to draw, a number of distinctions between the law in the US in any event. We suggest that their approach to comity is different to the approach in the United Kingdom and the rest of Europe. That's one reason why Justice Gorsuch's reasoning, even if it were in any way binding, is not persuasive. Secondly, we suggest that his reasoning would appear to bar the other categories of damage which we have been talking about, such as post-expiry, bridgehead damages or convoy goods. And thirdly, we submit that there's no extension of a UK patent monopoly actually involved in this case. As Mr. Justice Jacob pointed out in Gerber, as the majority pointed out in Western GECO, the mistake that Justice Gorsuch made is to fail to distinguish between the infringements and the damages flowing from the infringements. And we say, for those reasons, his reasoning just cannot be persuasive, and the judge, in this case, was right to ignore it in the same way as we submitted below. It's right that there's an article by Professor Holbrook that my own friend took you through to this morning, in which the judge was taken to, and he says that, argues that Justice Gorsuch's reasoning should be adopted. Equally, there was an article we put before the judge, and at tab 39, and which she referred to in 106 by Professor Cotter, where he says that the majority were right in Western GECO and provides all the policy reasons for that. If your lordships were interested in that, it's quite a long article. We've sought to sideline the most useful parts of it, but it makes for interesting policy reading if that's
Tab.
would it be of note. But as I say, it's only
Tab.
It's tab 39.
Thank you.
And if I can summarise his arguments, he first of all says that there is jurisdiction to grant extraterritorial relief in copyright cases, and he cites a decision of Judge Learned Hand on page 1195, Sheldon and NGM. He then goes on to point out that the courts in Canada do grant relief extending into the US in pharmaceutical cases, and there's nothing in principle wrong with that. That's on page 1197. Then he goes on to review Western GECO in a bit more detail, and his arguments and the policy discussion really starts at 1205, and then at 1211
Sorry, I just noticed from 1197 he cites an English case, Goucher and Clayton, admittedly from as long ago as 1865. But according to what he says here, the patent owner was entitled to recover the defendant's profits from sales of products in Austria, where the defendant had manufactured these products in England. Now, that sounds like an account of profits, but if you're right in the argument we were presenting earlier that the issue is essentially the same in the two different contexts, then that would seem to be material.
That may be of assistance. I can't remember whether we dug that out. No, I think your lordship has usually spotted something which there's appeared before and failed to. So I'm sorry that we haven't looked that up, but that lordship may well be right. He goes on to Western GECO on 1205, and then he deals really with the arguments on 1211. He says why the arguments are misguided in 1211, and some of the reasons he gives chime with Mr. Justice Jacob in Gerber, and this really is summarised on 1216. Where he and 1219, and he concludes there, firstly, that there is no expansion of US patent rights. Second, you can get the same sort of relief by an injunction, so why can't you get damages? Third, there are other contexts where you can stop convoyed goods, get relief for convoyed goods. So why should it make a difference? The geographic scope make a difference. And then finally on 1218 he says that there's an important deterrent effect, and patentees who know that they're infringing might be deterred with this sort of relief, and that's a good reason to allow it. So we say that there are just as many arguments, in fact we say better arguments, but at least there are arguments saying why Justice Gorsuch was wrong in the academic literature, and so the judge was right, having reviewed some of these articles and referred to them in 106, not to be persuaded by them to go against the tide of law that stands in the United Kingdom. The final case that my learned friend took your lordships to was the Hendricks case, and the only additional point I'd make on that, this was in 11, Joint Authorities 1. Albeit at only first instance. But the paragraph which my learned friend didn't take you to is paragraph 141 of that decision on page 421. And that is where Mr. Jones, for the claimant, was setting out the arguments which he said permitted relief to be granted for otherwise non-infringing acts. And if we just pick it up about halfway through the paragraph, it says, it was, he said, simply an issue of causation. And perhaps your lordships would just read to the end of the paragraph.
Yes. Yes.
And so this is really the point that my learned friend was making this morning, which say, well, if Rhodia had a Macedonian patent, they should have used a Macedonian patent to prevent the activities in Macedonia, not the UK patent. And what Mr. Justice Blackburn was pointing out here is that there may well be overlapping rights, and it may be possible to use other rights to prevent acts. But just because you might be able to dream up another right which you could use to prevent those acts doesn't mean that you should curtail the remedies that are available from the infringements you've proven and are relying on, as long as there's no double recovery. And both the authorities and indeed the academic articles make it clear that the courts are very used to ensuring that there isn't double recovery, and it's not been suggested that there would be double recovery here. And so we reject the submission that there's some policy reason which requires patentees to go around getting a patent in every single possible country they can, just because this sort of relief wouldn't be allowable on the facts of this case. And equally, it could have been said in Gerber that Gerber should have got a patent on their CAD machine, and the fact they didn't have a patent on their CAD machine didn't prevent them from getting damages for the sale of the CAD machines as convoy goods. And that argument could apply to any situation.
The problem with that argument is that some of the things for which there was recovery in Gerber would have plainly been unpatentable.
I accept that, of course, but there may be other intellectual property rights that could have been asserted against some of the goods that were recoverable. But it's certainly, as a matter of principle, our submission is that one can almost always think of some other way you might be able to recover for a convoy good, but that doesn't mean, if the facts are right, that you shouldn't be able to recover in the circumstances of Gerber, just as you shouldn't in the circumstances of this case for extraterritorial losses.
Well, there's a more general point, isn't there, about overlapping rights? I mean, you have that in all kinds of civil litigation. You know, a
Yes.
claim in contract and a claim in tort.
Yes.
And people who've left it late always sue in tort because the limitation period starts late.
Yes. But we see.
And they'll plead contract just in case.
Yes. But equally, we see some of these House of Lords cases, there have been claims brought under both at the same time, and they're not, as long as there isn't double recovery, they're not forced to choose one or the other. So, my lords, I think that deals with the submissions that my learned friends made this morning. For all the reasons I've given on my feet and we gave in writing, we say that the judge was right to come to the conclusion that he did on this issue. I'll just check if there's anything else that I want. In which case I will move to Respondents' Notice 2 point, and this is the Enforcement Directive and TRIPS.
I think it's just the Enforcement Directive.
Well, the judge dealt with it under the heading of TRIPS, and of course...
Apparently it wasn't drawn to her attention that TRIPS didn't have direct effect.
It was certainly drawn to her attention that TRIPS could only be have effect insofar as you could construe the English legislation consistent with it. So we didn't say that we suggested it had direct effect, but there wasn't a big dispute between us as to whether or not you could apply the principles to the English legislation. I need to go into the history a little bit, my lord, to explain why the judge dealt with it on the basis of TRIPS and not the Enforcement Directive. And this resulted in, there was a late point and there was submissions made post-judgment.
Well, does the history matter? Because surely we can concentrate on the Enforcement Directive, because we know that is applicable, and there's yards of jurisprudence from the Court of Justice about it, which can tell us how Article 3.2 is to be applied, specifically in the context of injunctions. all that does is to provide one with a secure foundation for considering whether it has any application in the circumstances of the present case. But it has the advantage that one doesn't need to start worrying one's head about how TRIPS becomes relevant.
No, I accept that, my lord. But the problem with the enforcement directive is, of course, that Article 3 has not been transposed into the UK legislation.
Well,
So
it
there was a
hasn't been
debate.
transposed into legislation, but that's not the issue, because you can implement a directive in more ways than one. And would you dispute that Article 3.2 has become part of domestic law? Because there's been a series of decisions of the English courts applying, in particular, the requirement of proportionality. I mean, I'm sure I don't need to remind you of certain decisions of my own in that regard.
Indeed, my lord, and I don't want to get sidetracked, because I think.
Well, exactly. None of this matters, does it?
No, but from a technical perspective, there was a question arose at the trial about whether or not it was post-Brexit. By the time we got to the trial, the judge was deciding the issue where Article 3 has not been transposed. The directive had not been brought into English legislation.
Why does any of that matter, given the claim was brought in 2016 and the infringing acts you will all rely upon were all committed well before 2020?
Of course, that's right. And the only debate then is whether do you apply the law as it is on the date you're making the award for damages, or do you apply the law prior to that? There was a debate between us at trial, which is maybe why the judge decided she'd rather decide it under TRIPS than under Article 3 and or...
yes, but I have problems with that.
I understand that, my lord, but I was just trying to explain some of the history. As I say, I don't think it makes any difference to us, because we say whether you look at Article 3, whether you look at the UK implementation of the Enforcement Directive, or whether you look at TRIPS, all of these are consistent with the approach that both the judge took and that we urged her to take at trial. So, my lord...
Nobody's saying that neither of these apply in one way or another.
Well, plainly, as my Lord Justice Arnold has pointed out, there is case law that says in the United Kingdom that awards should be proportionate, etc. And that there's no getting away from that, and we didn't seem to do so. But there is some technical questions about the effect of Brexit on the Enforcement Directive and what is actually now the law. But as I say, it probably doesn't matter, because the principles are the same, whether it's a TRIPS or the Enforcement Directive. And so I'll go on and address it on that basis. So, my lords, we support the judge's judgment for the reasons she gave. There's a question about legitimate trade and its meaning, which my learned friend addressed you on this morning. And we say that legitimate trade does not mean all non-infringing trade, to the extent that that would cover trade that has been caused by infringements or is otherwise objectionable as a result of infringing acts which have taken place. And that's really the difference between us. And it's where the judge, we say, found rightly in our favour and held that there was no...
So trade that is non-infringing can still be tainted?
Indeed. And not just that aspect of Article 41 of TRIPS, but it's the other aspects which also encompass the sort of relief that we are seeking in this case. And so if we take each of the pieces of legislation one by one, I can show you how it applies in each of the cases. So if we start off with TRIPS, which is at tab 42. So it's page 1245. And what Article 41 says, it says that enforcement procedures are available under their law so as to permit effective action against any act of infringement of intellectual property rights covered by this agreement, including expeditious remedies to prevent infringements and remedies which constitute a deterrent to further infringement. So here is an express acknowledgement of the policy highlighted by Mr. Justice Jacob in Gerber, that you are allowed to grant relief which acts as a deterrent. And in the absence of the sort of relief that Gerber allowed, and we say follows in this case, we say there would be insufficient deterrent to prevent the sort of conduct that Neo carried out and the profits that they made being prevented in future. And then Article 41.2, procedures concerning the enforcement shall be fair and equitable. They shall not be unnecessarily complicated or costly or entail unreasonable time limits or unwarranted delays. Again, we say nothing that we're seeking here is inconsistent with that. Then we come to the Enforcement Directive, which is at tab 46. And my learned friend took you to this this morning. And again, we see similar language on page 1269. Article 3.1, member states shall provide for measures, etc., to ensure the enforcement of the intellectual property rights covered by this directive. Those measures, procedures and remedies shall be fair and equitable and shall not be unnecessarily complicated or costly or entail unreasonable time limits or unwarranted delays. And then 2, those measures, procedures and remedies shall also be effective, proportionate and dissuasive. So again, we see this element of dissuasiveness, and shall be applied in such a manner as to avoid the creation of barriers to legitimate trade and to provide for safeguards against their abuse. And then if you flick on, please, to page 1285, you'll find the provision on damages.
Yeah, just before we get to that, it might be worth clearing out of the way a point which I don't understand to be in dispute. But on the face of Article 3, one might wonder whether this is an obligation that rests upon the member states or whether it rests upon the member states and upon the competent authorities within the member states. I don't understand it to be in dispute before us that the latter interpretation is the correct one.
That's, I think, the basis on which we proceed before the judge.
Well, and there's a lot of Court of Justice authority which would support that interpretation, although I don't think it's ever been squarely addressed in terms.
Yes, so I confirm we're not taking that point.
That's what I thought.
So page 1285 is the damage provision, and that states member states should ensure that the competent judicial authorities, on application of the injured party, order the infringer who knowingly or with reasonable grounds to know engaged in an infringing activity to pay the right holder damages appropriate to the actual prejudice suffered by him as a result of the infringement. So this is a ground which seems to suggest, contrary to my own friend's submissions earlier, that you should in fact be able to recover all losses where the defendant has knowingly engaged in infringing activity, as the judge has found here. So that is a generous provision, we say, which within which the judge's award in this case, were it not for my main finding on causation, would plainly fall. And the provision goes on, little a on the next page, they shall take into account all appropriate aspects such as the negative economic consequences, including lost profits, which the injured party has suffered, any unfair profits made by the infringer, and in appropriate cases, elements other than economic factors such as moral prejudice, etc. And then on 1287, Article 2 of Article 13.2, where the infringer did not knowingly or with reasonable grounds to know engage in infringing activity, member states may lay down that the judicial authorities may order the recovery of profits or the payment of damages, which may be pre-established. So that shows that there is a more generous provision envisaged for over and above ordinary damages for infringers who knowingly infringe, as Neo have been proven to here.
Well, is it possible to say that had it been intended by the directive to limit the assessment of damage by reference to territory, that it would have been perfectly possible for them to do so?
Of course. I mean, we make this, I was going to make this point at the end, but certainly one point to make is that the US law is governed by TRIPS. US law allows extraterritorial recovery, as we've seen in Western GECO, the majority. So there's no suggestion that that's incompatible with TRIPS. We've seen UK and some of the references to the European authorities and the proposed powers of the UPC. No one's suggesting that those are not compatible with this legislation. And if indeed it was the intention of the legislators to so limit, then I respectfully agree with your Lordship, that would have been made clear.
Right, so you say it's a speaking silence.
Indeed. And not only that, it actually clearly goes beyond ordinary damages for knowing infringers at least. And so it is not limiting in that respect either.
Yes.
And then finally, we have in tab 47, we have the way in which some of this has been incorporated into UK law, and we have Article 3 of the Intellectual Property Regulations, and this seeks to incorporate Article 13 we just looked at. And you see where in an action for infringement of an intellectual property right the defendant knew or had reasonable grounds to know that he engaged in infringing activity, damages awarded to the claimant shall be appropriate to the actual prejudice he suffered as a result of the infringement. And that would, in our submission, plainly encompass recovery of damages for extraterritorial sales. And so there's no bar in our submission on that recovery in this case, even if we're not expressly seeking to rely on these provisions to say that damages in this case are different to the ordinary damages in patent cases. So, my Lords,
So are the regulations there to give effect to the directive?
yes, that's it, but it doesn't. Article 3 doesn't appear in that in those regulations, which is the discussion I was having with Lord Justice Arnold earlier, and that there is could be said to be a problem with that, but the courts have got around it by imposing the principles of the enforcement directive directly in any event. So, my Lord, we say that, and finally we've relied on the Court of Justice case, which I took you to earlier, as indicating that, although it's an older case, in that case they didn't think that the post-expiry injunction granted by the Dutch courts infringed Articles 30 or 36, and that they were proportionate. And we say that that again is all of a piece, and all of these statutes, and indeed the way they've been interpreted by the courts, would allow, or certainly would not prevent, the awarding of relief in the present case that we sought and which the judge agreed with. My Lord, the only other point I think I need to deal with is proportionality.
Just before you do that, could you, I'm sure it's my fault, but I'm still slightly struggling with this. You said a little earlier that legitimate trade doesn't mean all non-infringing trade, to the extent that that would cover trade that's been caused by infringements or is otherwise objectionable as a result of an infringing act.
Yes.
So you say what? That this fits that category?
Yes.
And therefore, what's the effect of that?
That granting damages in relation to the sales to Macedonia doesn't contravene the legislation which says that you should allow legitimate trade.
But you have other reasons for saying it doesn't contravene it.
So, I'm sorry,
You have
yes,
other
we do,
reasons.
Indeed, we do. Yes,
So,
yes.
so
I mean, is this a knockout blow? Is the legitimacy point a knockout blow? I mean, it's not something the judge dealt with, which was the point I was discussing with
Yes, I mean,
Mr. Culligan this morning.
yes.
So I'm just trying to see where you deploy this as simply one of a number of points. Is that right?
That's right. And we say that they're all trying to achieve the same end, which is to make sure that damages and other relief is proportionate and doesn't go too far.
Right.
But that does not prevent, in the right circumstances, otherwise non-infringing acts being injuncted or damages being payable for them. Because we say that the sales in Macedonia, of course, based as they were on the gateway infringing activities in the United Kingdom, were illegitimate, and that they're not prevented. Damages are not prevented by that provision.
Thank you very much. Sorry, I interrupted. You were going on to proportionality.
Yes. And my junior helpfully points out that this was really addressed by the judge in 116 of the judgment, where she did deal with barriers to legitimate trade, and she holds that damages in respect of non-infringing overseas sales should not be regarded as creating any more of a barrier to legitimate trade than a claim in respect of non-infringing domestic sales.
Yeah.
Which, as she says, might equally involve an international supply chain. So really, it's again drawing a parallel between the Gerber type situation where you are effectively either injuncting or getting damages on otherwise legitimate sales or otherwise non-infringing sales, and that isn't not objectionable either. Now the point that my learned friend skipped over today, and my learned junior will give me the right reference when I've explained it, that as we understand it, my learned friend doesn't say that the payment of royalties is a barrier to legitimate trade. So although he makes the submission generally that the judge was wrong to come to the findings she did, as we understand it, he accepts that if the damages were limited to a reasonable royalty, then that would not be a barrier to legitimate trade. Now, I'll get the... Now I've asked my junior for the reference, he's going to provide it. So we say that this is, even on my learned friend's case, this Respondent's Notice 2 point is not a complete answer to the award that the judge made, because he is forced to accept that royalties would not be a barrier to legitimate trade, and this is the point he concedes in paragraph 51 of his written submissions
All right.
for this court.
Anything else on RN2?
I'm sorry, what?
How are we getting on with RN2?
Yeah, we're getting on pretty well. I may run out of notes if I continue to go so fast, but perhaps I could indulge your lordships if there's anything I've missed out in the morning. I will just check if there's anything else I wish to please address you on RN2, otherwise we can move on.
I think the only question is whether there's any more you wish to say on proportionality as opposed to legitimate trade.
I might take up your lordship's invitation.
But as I understand it, your argument is essentially the same. There's nothing disproportionate about it for really the same reasons.
Indeed, and I think this is where we rely on the generics case.
Yes.
I appreciate different legislation, but the principle is plainly the same, that the European Court was held that it was not disproportionate for the Dutch court to grant post-expiry relief.
Yes.
And we say that applies equally to the enforcement directive. Same word, same principle. Yes, and the judge dealt with this in 115, and she held that if there is sufficiently proximate causal connection between the infringement and the loss, it's difficult to see why the claimant's recovery of that loss should be regarded as disproportionate. So we say that if we're right on our main appeal, then that, for the reasons the judge gave, that would fold in proportionality as well. And of course, in this case, my learned friend gave some colourful examples and seeks to rely heavily on the difference between the amounts of material imported into the UK and the amounts sold in Macedonia and South Africa. But of course, that's the whole basis upon which this sort of contract is gained. There were amounts imported into the UK. They weren't insignificant. They were significant enough for all the prototypes to be made, all the testing to be done, the specification to be agreed. That was the gateway, and that set up what everyone intended, which was very significant sales over a long period in South Africa and Macedonia. But as that was expected and intended, then it's not disproportionate to grant relief in respect of those expected and intended sales when the work that was carried out here initially was so crucial to gaining them in the first place. And you've seen the judge's findings in any event on the amount of work and the length of time that it takes to get these goods qualified. So even if the amounts are quite small, in terms of tonnage, we say that it's still proportionate to grant relief in respect of all those sales, given the amount of work that went on in the UK and the extent of the infringements that took place. Finally, it may not be relevant to any of these issues, but and the judge didn't refer to it expressly, but I should point out that every single sale that was made to Macedonia and or South Africa was made by Neo UK. So she doesn't.
What?
So there was economic activity taking place in the United Kingdom.
When you say economic activity, let's assume that there had been no infringing acts within the UK. How would the fact that the non-infringing acts involved a UK company assist you?
Well, obviously that's a different situation. The point my learned friend sought to say, well, it's disproportionate to grant relief in the UK when the majority of the acts are taking place elsewhere, and the more proper place to grant this relief is Macedonia, etc. And that is where the relief might be more, and also you're interfering with, potentially interfering with economic activity in Macedonia. But the monies were all being channeled through the UK, and so it would be wrong to suggest.
How do we know that?
Because all the invoices came from the UK, Neo UK.
But I repeat, how do we know? Where is the finding of fact by the judge that the monies were paid into a UK bank account even?
Well, that wasn't an issue. We had the invoices were given on display,
Yeah,
which
but
were all invoices.
you could invoice a UK company and still pay the money into Cayman.
Well, that may be, but the simple point I'm trying to make, my lord, is that just because there were overseas supplies doesn't mean there was no economic activity in the UK, and that is.
Well, it all depends on what you mean by economic activity, doesn't it? As to which we've got a complete absence of findings, probably due to an absence of evidence.
That's certainly the case, Mark.
All right. Are we
that I think probably deals with Respondents Notice 2.
Right.
Respondents Notice 3 is not going to take me very long. It didn't take my learned friend very long. This really is, in our submission, an attempt to rerun the arguments that we've already been over on the main appeal.
Well, with that ringing in our ears, do you want to breathe life into those arguments? Is there anything particular that you need to...
I think the only point I would seek to make in answer, this was the patent flavour point, and he was relying on manufacture in China, importation and local patent manufacture in Macedonia and South Africa. These were points that he ran in front of the judge, and the judge rejected them. And she summarised them in paragraph 79.3 of the judgment. That's where she pointed out that these arguments were being made. So the most proximate causes of those sales were the manufacture in China and the procurement decisions at the individual production plants, etc. And then she rejects them outright in paragraph 161. And we say, really, that's the beginning and end of it, and no real attempt, quite properly, by my learned friend to re-argue the facts from scratch for your lordships. And really, this isn't a proper Respondent's Notice point, because he didn't identify any errors of principle in the judge's findings, having correctly summarised the arguments and then correctly rejected them. We say he would like to do so.
Right.
So that brings us on to Respondent's Notice 4 and the licensing point. And we say that this is one of those sorts of decisions which arises in inquiries of this nature, and the judge had all the right principles in mind when she summarised them at the beginning of paragraph 82, in particular 82.9, where damages are difficult to assess with precision. The court should make the best estimate it can in regard to all the circumstances of the case, dealing with the matter broadly with common sense and fairness. And she did assess the evidence. There was evidence before her. She did take into account the arguments, and she came to the view that the royalty rate awarded should be somewhere in between that of the two experts. And there was every reason for her to come to that view, based on the reasoning she gave, and no criticism could be made of her for having done so. So that's the overall submission. If I try and take it in a bit more detail and deal with the submissions my own friend made as he went through. Firstly, we start at 266 of the judgment, which is where the judge set out the pleaded case. And of course, your lordships will understand the reason that it was said in this case that even though the licence had to be restricted to a UK licence, that should take into account global sales, is because this was the gateway or the precondition to global sales. Without the UK activities, there would be no global sales whatsoever.
Yeah, so there's nothing wrong with your pleading.
Yes.
What's wrong with your case is your expert proceeded on a different basis to that which you pleaded.
Well, he certainly took into, he made assumptions about certain things which turned out not to be correct in the light of the judge's findings. And so,
Well, no. She says he didn't value a UK licence with global sales, which was your pleading. What he valued was a global licence with worldwide rights.
yes, and so the difference.
So the problem is that there's a disconnect between your pleaded case, which is perfectly correct as the judge held, and then the expert evidence which doesn't support the pleaded case. So that's the problem.
But the judge did have expert evidence from both experts dealing with this issue.
Well, Mr. Bolton proceeded on the same basis.
Well,
we've seen.
he did, but he had an important caveat, and I was going to show you this. In the supplementary bundle at tab, it was page 171.
Yes.
So the point, my own friend took you through paragraph 5.24, and if we go through them one by one, little one, it's right that the judge had to take into account the Chinese patent and what discount would be awarded on the royalty rates that were originally claimed, because the Chinese patent was still out there, and so commercially there needs to be a total discount to take account of that. Little 2, Mr. Bolton says, well, an agreement along these lines is not commercially rational. That might be right, but this is an artificial situation in any event, because we're trying to value a notional license which wasn't actually entered into, and we're trying to do it within the constraints of the law, which mean we can only plead a UK license, when in fact the parties commercially might have sat down and agreed a worldwide license, but we're confined not to be able to do that. So it may well be commercially unlikely to take place, but that's the constraints that the judge found herself in. It's the fourth point, really, that my learned friend didn't alight on, and we say is important, because the criticism that Mr. Bolton made, he said the disconnect between a local UK licence and global royalties at Rhodia's contribution margin in the notional licence, assumed by Rhodia, only makes commercial sense in a situation where there is no realistic possibility of Neo achieving overseas sales without having carried out the infringing acts in the UK. That is a factual dispute before the court. Now, he was right about that, of course, because when he wrote this, it was a factual dispute before the court. But the judge has resolved that factual dispute in Rhodia's favour, and has held that, in fact, there was no other situation in which Neo could have acted other than by carrying out the infringing acts in the UK. So by making that finding, a number of the criticisms that Mr. Bolton made fall away, and that allows the judge to do the best she can with Mr. Bolton's evidence, starting at 25%, and Mr. Bazant's evidence, starting at 50%, with the acknowledgement that Mr. Bazant was overvaluing things because of the presence of the Chinese license, the Chinese patent. And so, when the judge came to try to resolve this issue, having correctly identified the
Sorry, can you identify us? Where in Mr. Bolton's report does he give the 25%?
That may not be in the bundles, my lord.
All right, well, can you supply us with the additional page?
Yes, of course. So the judge had to deal with, and it may be said that Mr. Bolton may be right in what he said, but it wasn't necessarily the most helpful approach to say, well, I can't value this for certain reasons. So the judge is left with a valuation on one side and not the other. But that was something that Neo chose to put forward. So the judge has to do the best she can. Paragraph 273, she correctly identifies the problem. But then in 274, she acknowledges Neo is right to say that the notional licence would not have guaranteed it the right to sell throughout the world. That's correct. But then she goes on to say, but that does not make it impossible to value a licence on the basis pleaded by Rhodia. And she goes on to make some observations about that. It is a somewhat abstract exercise, but you have to assume there's a willing licensor or unwilling licensee, even if that wouldn't exist in practice, and even if the result is rather artificial, it's not a reason to reject the exercise altogether. The court simply has to do the best that it can on the material available to it. So she acknowledges that it's not perfect, but in these sorts of...
I don't understand that. So help me. So it's your case that you're entitled to a reasonable royalty. You plead a case which is perfectly sustainable in principle, and then you adduce expert evidence which doesn't support the pleaded case. Now, why then is the judge, as she puts it, to do the best it can on the material available? Why isn't it a simple case that you failed to discharge the burden of proof you set for yourself?
Well, because the judge found that just because Mr. Bazant had wrongly valued this aspect of the case doesn't mean that she had to throw out all his evidence altogether. And she makes she makes that observation in 278 where she says that he had overvalued it. She acknowledges that, And then in 281, which is not a paragraph one over and took you to, she says, I do not, however, agree with Neo that the only way of doing so is to reject Rhodia's global license fee claim in its entirety and replace it with a license fee confined to the licensing of Neo's development samples. Mr. Bazant's erroneous assumption that the notional license would give Neo global rights to manufacture and sell did not taint the entirety of his approach to the quantification of the notional license, related specifically to the prices at which he assumed that Neo would be able to sell its product to JM. As I set out below, that error can be corrected by taking an alternative reference basis for those prices. So she assessed on the evidence that Mr. Bazant's mistake didn't go to the percentages that he had put forward, but instead went to the base price which he had assumed that Neo would be able to sell at. And he thought that Neo would be able to sell at Rhodia's price. And the judge found, having heard the evidence and the extensive cross-examination of both witnesses, that was not right, and that in fact it would be Neo's price that should be used as the royalty setting price. She then went on to apply the expert evidence on the percentages of what profit should be assigned to Rhodia, and she took into account Mr. Bazant's figure of 50, which she said was not tainted by his erroneous assumption about the Chinese patent, and she took Mr. Bolton's figure of 25, and having assessed the evidence overall, she came up with a figure of 35%. And we say that is an absolutely classic decision of a trial judge who is presented with conflicting evidence, listens to the cross-examination, assesses the arguments, correctly records them, and then comes to a decision based doing the best she can on the materials before her.
Okay, so if I've understood, sorry.
After you.
So you didn't take it specifically to it, but as I understand what you've just said, it therefore paragraph 288 becomes important, because what you're saying there is that that's where she strips out Mr. Bazant's error.
Yes, it's a combination of 281 and 288.
Right, and so you say she did adjust in a way that would affect the bottom line on the amount payable.
Yes.
But she did it by reference to price rather than royalty percentage.
Correct.
And she did that in 288.
Yes, and then in 289 she goes on to consider Mr. Bolton's scenario B based on Neo's prices, which is what she had held was the right price to start with. And she says that's consistent with my conclusions that they remain unlicensed, but they're the sole source of supply, etc. And so she accepts overall that that's the basis that should be used.
276.
Yes, I'm sorry. I'm sorry, my lord. The point of 289 is that the reality that Neo found themselves in, where they were in fact having to face the issue of the Chinese patent and the price they set commercially in the reality took that into account, was also the position that she should impose based on the notional license.
I just was drawing attention to 276. I know we've all read it, but in this context, it seems relevant to my lord's question about whether your case was supported by your evidence. The judge seems to me to have gone through this exercise extremely fully, actually more fully than many of the other passages in the judgment. And the alternative for her was simply saying, because this is a bit of a muddle, and this wouldn't be a real life situation anyhow, you get nothing.
Yes. I throw my hands in the air and say that, yes, you haven't satisfied the burden.
Got that point.
Yeah.
Can I just ask this, in relation to the two percentages that she had in mind, that she then arrived at 35%, that's at 291.
Yes.
Is that an agreement between the experts in writing? She says it was agreed, or do we get that from different bits of their reports?
I think you get that from different bits of the reports. I'll check that overnight, my lord.
If you would.
I mean, these are, my Lord Justice Arnold will be familiar with both of these names. These are two experts who've given evidence in
Countless cases.
Countless cases. So they
So they'd be very familiar with producing a document under Part 36 recording their agreements. Must do it all the time.
I'm afraid, as you may know, my lord, that happens less often in the Patents Court than in other.
It would be a great shame if that was an agreement that we had to discern by reference to numerous bits of documents rather than one agreement. Anyway, let's hope that the civil procedural rules were complied with.
My lord, we will check that overnight. But certainly, these sort of numbers, they come both from experience in industry and previous case law, where you're talking about trying to divide up the benefits and the numbers of 25% and 50%.
I'm just thinking of the assistance to be provided to the judge.
Of course, my lord, yes.
All right.
So, my lord, unless anyone tugs me from behind, I think that deals with Respondent's Notice 4.
Thank you.
There was the Eaton Mansions point was raised just at the end. I have to confess that in our submission, that probably, if the judge missed it, we certainly hadn't realised she'd missed it, but if she missed it, that probably is something she should have been reminded of when the draft judgment came down, if my learned friends wished to ask her to determine it and say whether it made any difference to the outcome of her decision. We respectfully submit that it shouldn't do on the facts of this case, where the end of the licence that she found is about coterminous with the end of the infringing activities, and for those reasons it shouldn't make any difference to the overall result. Just returning to the point, Your Lordship, the discussion we were having earlier about the payments to the UK, whether it matters or not, there is a reference to that in paragraph 47 of my learned friend's skeleton, where they say Neo may have received payment in the UK, but that was payment for conducting legitimate trade. Now, I'm not going to construe my learned friend's skeleton to see, is that an admission they did? Certainly wasn't in dispute, wasn't an issue before the judge. But his point, of course, is, well, even if they did receive money in the UK, it's not a reason to find that the trade was illegitimate.
All right, thank you.
Right. Now, Mr. Cadigan, you're going to have a reply on this, are you, at some?
That was my intention, my lord.
Yes. How long will it be?
I would think about half an hour.
Right. We'll do that tomorrow. And that leaves only the permission application and strike out and so forth.
Yes.
Right. We'll finish within the morning? We'll finish within the morning. All right.